Hello, everyone. This is Brian Jackson. Welcome to our podcast. We have a good episode today. Very, very important topic that I think everyone should know about. I've got my festive gear on, ready to talk about this. If for whatever reason you see this video after the festive season, happy Festivus to you anyway. And yeah, today we're talking about a very hot topic in the political arena. It's probably always been the hottest topic for quite some time, and that is abortion. And we're going to talk about Roe v. Wade, and then we're going to talk about Dobbs v. Jackson. But before that, we're going to talk about how things were set up for Roe v. Wade to come up with a decision that came out. Then we're going to talk about the decision of Roe v. Wade, and then we're going to talk about Dobbs v. Jackson and the implications and everything. And this is very important, and a lot of people really don't understand the legal underpinnings on how these decisions came about. And so I'm going to talk about that. And it all lies in the 14th Amendment. And also, too, I hope everyone understands and knows that I don't have any political bias, or I don't have a motive to have someone think one way politically, one way or another. My whole purpose is to teach people the law and understand the law. And I don't personally pledge allegiance to any political party. I'm willing to take shots at either political party. And I'm sure that if I ever ran for public office, they would take these videos that I use and mush them to say that, hey, wait a minute, that's not your stance. So I've pretty much torpedoed myself running for public office, but that's totally fine with me. So let's get into this. So one of my podcasts was on the 14th Amendment, and that is like a 500-foot view, what they teach you in law school. So that's a good podcast to take a look at. And this all involves the 14th Amendment. So I'm just going to talk about a little bit about that for the groundwork so you can understand where we're going here and where this is all coming from. So the 14th Amendment, it says, no state shall, and then it goes through deprive privileges, liberties, immunities of the citizens, and shall not deprive citizens of life, liberty, property without due process of law and equal protection, and not discriminating based off race. And so there's a lot in there, but really what it is, it's like a criminal statute for the states. And this 14th Amendment came out in the 1860s after the Civil War era. So it's a fairly new statute, constitutional part of our Constitution compared to some of the stuff that came out in 1776. So it's taken a while for judges to figure out what this means and how it applies to the states. But again, it's like a criminal statute saying, states, you can't do this. There are things you cannot do. And that's important to understand where we're getting at here. So there was a case in 1925 called Pierce versus Society of Sisters. Pierce versus Society of Sisters. And essentially it was pretty much a statute saying that all kids had to go to public schools. And so when we're dealing a lot with the 14th Amendment, we're dealing with states and laws that they passed. And when we talk about whether or not it's unconstitutional or not, courts look at the 14th Amendment because the 14th Amendment ties states to the federal Constitution. Before that, they weren't necessarily tied to the Constitution. And so they were only held to their own constitutions. And the federal Constitution was just the federal government. And so there was more separate powers back then. But now they're somewhat held more accountable under federal law. And so So these laws, that's what we're looking at. We're using the 14th Amendment to determine whether or not these laws are unconstitutional. So there's a law that passed saying that, hey, you have to take your kids to public school. So somebody sued, said, hey, you can't pass this law. And so the Supreme Court in 1925 came out and said essentially that parents have a liberty interest, and they have the liberty to choose where their children go to school. So that's the gist of it. And so they struck down that law saying parents have the right to decide education and whether or not they go to public education or not under the Constitution. So that pretty much meant that states could not make requirements like that. So that was kind of a big landmarkish case for the 14th Amendment in carving out some rights here. And then it goes on, and there's another case that comes out in Connecticut. And Connecticut passed a law that this was like in the 60s now. So we're fast forwarding about 40 years from Pierce v. Society of Sisters. And at this time, there was a lot of debate on contraceptives and the use of contraceptives and birth control. And so Connecticut passed a law banning contraceptives. So nobody in the state of Connecticut could use contraceptives. And so, again, it's a law by Connecticut's 14th Amendment kicks in. And at that time, the Supreme Court came out and they cite this Pierce v. Society of Sisters case. So that's kind of the important groundwork here. And so they come up with kind of another right that people have that states can't impose on. And this was specifically, the people who sued was a married couple. And so they said that there is a liberty, kind of like privacy right of married couples to decide whether or not they want to use contraceptives in the privacy of their home, and that the government can't step in and say, no, you can't use contraceptives. And then later there was another kind of related case similar to that came out, and the Supreme Court came out and said, oh, this just doesn't apply to married couples, because it kind of created a double standard now, because I think thereafter there was a law that passed that said married couples could, because of that decision, married couples could decide to use contraceptives or not, but non-married people were still required to not use contraceptives. So Supreme Court came out and said, no, everyone can choose, pretty much have a liberty interest in deciding whether or not they can choose to use contraceptives, and the state can't step in and make a law against that. So that's kind of the background framework. But also what's important in those cases, in those contraceptive cases, so Pierce kind of set the foundation, but then so the case in Connecticut, Griswold v. Connecticut, kind of even enforced the foundation. And I remember first reading this case when I was in law school. And so what the justices decided there was, they kind of like, I guess you can say it was like they stepped back like 10 feet. Like, say the Constitution was right here, they stepped 10 feet away from the Constitution and they squinted at it. So they took a very large, broad view of the Constitution. They said, okay, look, we've got the Fourth Amendment here, where no search and seizures. We've got the First Amendment, right to assemble. And then we've got the Ninth Amendment that talks about some kind of righty stuff. And so so they said that just stepping back and squinting at the Constitution, we think that there is a right to privacy of the citizens that the state can't step into and impose on. So first, the right to privacy in Griswold was just for married couples. We think there's a right to privacy for married couples. And then it got broader and said, no, there's a right to privacy for everyone when it comes to contraceptives. And I remember when I first read that case, so this is my personal opinion, it's not political or not, this was just my legal analysis, was, in the legal world, you need logic. Like this, because of this, because of this. And and especially when you're interpreting the Constitution, very important. And so what they said was, all those Bill of rights, individual rights that people have under the Constitution created a penumbra, is the word they use, of rights. And that was used by Justice Jackson in a decision prior, and they grabbed on that, and he said it violated equal protection of the 14th Amendment. But they said, no, so they grabbed onto that, but they said it's not equal protection, it's due process. This violates the due process part of the 14th Amendment. And so that's where it came from. And so my issue was that seemed like a stretch, a very big stretch, because there is nothing specifically in the Constitution that says you have a right to privacy. And that kind of approach of stepping back and squinting, I think, is a very scary and bad, unfounded approach, because you could essentially invent anything, saying that, oh, well, this is in the Constitution, this is in the Constitution, where it doesn't expressly say it's in the Constitution. So a lot of judges, have their ways and approaches about interpreting the Constitution. So Justice Scalia, and he picked up on like Justice Frankfurter. Scalia was conservative, Frankfurter was liberal, but both their approaches were strict textualists, saying like, well, first we look to the actual text, and if it's not in there, then usually it's sorry, it's not in there. And that's not just reading the Constitution, but any law. And so when judges kind of go outside that textual thing, you're kind of on shaky ground, and it's kind of like them amending the Constitution, because it is so hard to amend the Constitution. You need 2/3 votes of Congress and Senate, and you need the president to sign off on it. And it's almost impossible, especially in our political world right now, to get the Constitution amended. And so it's scary where instead of having, X amount, 400 people in Congress, 100 people in the Senate deciding and voting and debating, you have a smaller group of people, 9 people. And so that's, for me, why it's so scary, is if you are running into something where it's not specifically in there, that could run into the grounds of judges actually creating law and amending the Constitution. And so, quite frankly, my personal opinion, I don't think this is political, but I did not think that was well-grounded law when I first read that in law school. I thought that was a really bad, illogical approach in interpreting law. Politics aside, just from a logical standpoint, there's no way you could just read in the right to privacy, because, you have the Fourth Amendment from searches and seizures. So, the government can't come in and search and seize your home, but also they can when they have probable cause. So without it's the Fourth Amendment says that if they have a warrant with probable cause signed by a neutral magistrate, then they can come in and search your home. But they're kind of giving an even stronger right here, where the government can never come in on your privacy, period, ever. I mean, I guess obviously there's exceptions if it's somehow related to something criminal, they can come in, but they're pretty much giving a complete bar on what the state can do where it's not in the Constitution. So that is the groundwork that we have with Roe v. Wade. And so it's not just, the political arguments on abortion, on why people personally think abortion is good or bad, but also on the legal side, people don't understand there was a big back and forth on what, like, how can you come up with this decision? Because and based off the interpretation of the Constitution, so a lot of people thought that it wasn't grounded in the Constitution even, and that the legal opinion didn't hold water. So let's talk. So I guess I'm jumping ahead. Let's go to Roe v. Wade now. So we get to Roe v. Wade, and that's the behind the scenes groundwork of where we were legally with the 14th Amendment when Roe v. Wade showed up. So Roe v. Wade showed up like in the 60s, and so what it was a law, or I guess there's a there's a law in Texas that criminalized people from performing abortions. So we have another law, and it just didn't criminalize the women having abortions, but it criminalized the doctors. And so this Roe v. Wade case involved a lot of individuals that sued a doctor and the actual people who received the abortion. And so they're saying this violates my constitutional rights. This is a government passing a law that is invading on my privacy. So we go back to the contraceptive stuff. And so that's what they're arguing. They're saying there's no difference. A woman can make a choice on what she can do with her body. She can make this medical decision, and they're saying that she can't decide to make a medical decision. And the state I would probably use the argument. Their argument would have to have been, number one, this doesn't apply to abortions. Abortion is different, so try and differentiate that from contraceptives. So the big picture is like, okay, what's a medical decision is what the abortion people would say is this is the same as a medical decision. They'd say, no, it's not the same as a medical decision. This is different. This is an abortion. And there's different stuff that we're dealing with here. And the state would also, it's an uphill battle for the state too, because they have this 14th Amendment decision, because there is some legal argument for them to say that it's legal, that they can do this based off the prior decision. So the state pretty much has to tell the Supreme Court to overturn Griswold and overturn the other Connecticut case. And so the state really had, in a lot of ways, an uphill battle. And so really their only argument would be to try and differentiate abortions as a different type of medical decision that could still be regulated than contraceptives. And so now we come to the decision of the Supreme Court, and this was actually the opinion by Justice Ginsburg. So this was her big opinion here. And so what the Supreme Court did in the opinion of Roe v. Wade is they went through the history of abortions, and they said, well, going way back to the times of, China, or I can't remember what, they were quoting like thousands of years back. They say we have evidence that there were abortions conducted, and then they went into the United States and they said there were abortions conducted here and here, and so they kind of go into the legislative history, and also at this, so I mean, at this time too, there were obviously states that were regulating abortions and saying abortions are illegal, and or so, some of them had exceptions. Some of them, I don't know what the legal groundwork was for all 50 states at that time, if there were all out bans or not. Um, and so, yeah, a lot of states with different rules, some more liberal, some more conservative. And and I guess what I don't like too about Roe v. Wade, the issue that I have with the decision of Roe v. Wade was their use of history, because in coming up with a legal decision and interpreting the Constitution, because I mean, we all know that history is always in the eyes of the winner or the beholder, and there's always two sides to the story. And you can use history to interpret however you want it, and you can cherry pick whatever parts of history you want to support your decision. And I think that's what they did in Roe v. Wade. And so I mean, like the whole abortion issue aside, like if we just set that aside and it was another issue they were deciding, I don't like this. I don't like how you cherry pick things to say, well, this applies to the Constitution now because of that's what history is. Um, so yeah, I think that again was an illogical step in interpreting a very important part of our country, and so I didn't agree with that, but ultimately, and also, so the other thing about Roe v. Wade that makes this so contentious and so hard to figure out is, I mean, with contraceptives, you're just talking about the liberty interest of the person using contraceptives. But we have two issues here. We have the right of the woman and her right to use contraceptives, or I'm sorry, her decision to have an abortion, and her liberty interest to make her own medical decisions, and that's the liberal side is saying, hey, women should have the right to make decisions with their own body, and whether or not they want to go through a pregnancy and have to rear a child. Like, this should be their right. We don't want the government, we don't want men, governments coming in and telling us women what to do. So for a lot of people, it's a women's rights issue, and allowing them to choose and how this affects their life and everything. And then on the other side, on the conservative side, they're thinking about the fetus and the baby. And they say, well, what about the rights of this baby? Doesn't this baby have rights too that should be protected? And so always the big question is, when does life happen? When does a human become a human? And that's always been the big fight, is the timing, essentially. Like, does it happen at conception? Does it happen 1, 2, 3, 4, 5, 6, 7 weeks? When does it happen? That's been always the big fight. And I think most Americans, I think the general consensus of Americans is that obviously late stages, no. And but also there are exceptions, like if it's going to affect the health of the mother, to save the life of the mother, other exceptions like rape and stuff. And most general people generally say, okay, that's fine. Um, and so that is the issue. And so the other problem with Roe v. Wade, and again, I don't want to make this political. I would say, again, if this was any other case, if it was whether or not it was a liberal or conservative issue, the another thing they came up with, I think it was a problem, was they had to wrestle with these two rights, and so they had to say, okay, when this women has this liberty interest, but then this unborn child liberty interest, and so they kind of weighed it on like, okay, when does the liberty interest of the child grow? When do those rights get stronger? And that's kind of what they looked at as um, when, yeah, when does the liberty interest of this unborn fetus kick in, essentially? Um, and and I guess what's interesting to know too, on a side note with this, is at and there still are statutes out there like this, and at that time there's statutes like that too, where if you if a woman is pregnant and you do something to her physically and it causes the fetus to die, you can be charged with murder. So that's an issue too, because I mean, if you can get charged with murder, and that's a big thing that conservatives, look at, and kind of the double-edged sword is, if you can be charged with murder, then then how could why wouldn't a woman be charged with murder for committing abortions, and the doctors, and you have the conservatives that always have the signs of the bloody fetuses when they protest. So that's the conservative side too, what they're arguing, and so what the Supreme Court did at that time is they looked to science, which is the issue I have. Is they said, okay, well, looking at things here, it looks like, a baby can't survive outside of the womb in the first trimester, but maybe second trimester has a better chance, and third trimester definitely outside the womb can survive. So that's how they did the sliding scale of the liberty rights of the baby. So they said, the woman's liberty interest is way stronger first trimester. So they pretty much said first trimester, green light. And then second trimester, they said that the baby's interest comes a little bit stronger. And so at that point, I think that's kind of where the life of the mother, health of the mother, you have to weigh those things on whether or not abortion should be conducted second trimester. And then third trimester was off limits. So that was Roe v. Wade, essentially. And so the issue with that is, in how they weighed that, is they had to look to science at the time, and the science that existed in a baby being alive at that time. And that isn't something that a Supreme Court should do in my mind, because they're essentially the fact finders at that point. And in at the on appellate review, you're not finding facts, you're not listening for facts, they're not trying to prove things for you, they're just looking at the record. They're just looking at the record on appeal and saying, okay, this is what was said on appeal. These were the facts. The facts are already in existence. And they're just looking at the facts and looking at the law and making a decision based off that. But here, they're still deciding facts on the appellate level. So that, I mean, to me, that completely bizarre, and that's not what the Supreme Court should be doing, is figuring out facts when the facts were already figured out way back then. And that really is, I mean, in my mind, if you're talking about science and if you're arguing on when is and isn't that in, and I guess, I guess this is more a pro-conservative approach, but in my mind, even if it was abortion or another thing, that is something that should be left to legislatures, lawmakers to decide, to debate and determine instead of judges. Um, so, but anyways, that's so there. There's a lot of legal holes with the Roe v. Wade decision um, because of their determination of facts and using science to make a legal opinion, and then also with this really shaky ground, illogical issue of finding this right to privacy. And so that's how Roe v. Wade was grounded. And so if you just look at it from a legal perspective, it is not well-founded law. It's on shaky law. And maybe that hurts hearing it from a liberal standpoint, because obviously abortion is people have their opinions and they feel very strongly about this, and it hurts to hear someone say that, hey, this is stupid. But I'm just telling you, from an illegal analysis standpoint, it was a very shaky decision, and that's why it wasn't. That's why it was so contentious, because you again had contention on, are you killing a baby, the right of a woman, but then also contention on, like, this is a completely unfounded legal decision. How can you support this legal decision, and whatnot? So, but the thing is, then too, is they continued to use, that right to privacy kind of framework to come up with other decisions too. So another case that came out after that was Lawrence v. Texas, where two men who were having intercourse in their home, and there was a law passed by Texas that criminalized sodomy, and so they got charged with it, and so they sued and they said, this is unconstitutional, this violates my right to privacy. And so the Supreme Court came out and said that, yes, this violates their right to privacy, struck that down. And in law school, when you're learning about these cases and you're talking about 14th Amendment, I mean, I was there, I was in law school before the gay marriage thing came up, but just the way they taught it, and the right to privacy thing, and how, I mean, so with all these cases that they kept coming up with, kept solidifying this right to privacy, right to privacy, right to privacy. And so when you get the topic of gay marriage, I mean, from a legal perspective, based off precedent, based off all the cases that keep relying on the right to privacy, and if they keep relying on the right to privacy, when it came to gay marriage, I mean, again, before any decisions came out, I could see the writing on the wall. Like, there was no, like, if they continue to say yes, right to privacy, there's no way that gay laws banning gay marriages could be upheld, because it's no difference than the Griswold cases, where specifically saying that laws where you can't come in and tell married couples what to do. You can't come in and tell people, what kind of decisions they can make to their on whether or not to have a baby, contraceptives, and then also have abortion or not. And so, I mean, it just lined up with that logic, right to privacy, that states you cannot come in and say you can get married, you can't get married. So really, the writing was on the law and on the wall from what I saw. So now let's fast forward to where we are now. So for the first time in almost 70, 80 years, so for 70, 80 years, like starting in the 40s-ish, we had a liberal Supreme Court. Before that, we had conservative Supreme Court, like going back almost Civil War-ish. So there was kind of a Civil War conservative era, post-Civil War conservative era, and then we had a liberal era. Now we have a conservative court again for the first time. And and so there was an opinion that came out, and also I just note that Justice Clarence Thomas hated Roe v. Wade, and he hated the legal arguments and the interpretation of the 14th Amendment. And he, for years and years, in all his opinions, he has always found a way to attack Roe v. Wade in all his decisions. Even if it was completely unrelated, he'd go back to Roe v. Wade. And so you could tell that, he hated the Roe v. Wade decision. And there was a case that came out on a gun right case in New York by this new conservative court. And this was before the overturning of Roe v. Wade. And I thought this was an interesting decision, and this might kind of give a glimpse into where we're headed, and I don't like it either. So I'm telling you, I take shots both sides. Liberal, conservatives took shots at a liberal opinion. Now I'm going to take shots at a conservative opinion, because their gun right decision kind of went through kind of analysis on what rights you have under the Constitution, and how to identify when you have a liberty right. So like when you have, because technically there's still rights under Pierce Society of Sisters. There's still a right to decide if public or private education for your kid, and there's still rights to the medical decisions, contraceptive stuff, and also marriages, and also a lot what the 14th Amendment was protecting marriages, and they slowly gave illegitimate fathers more and more rights to their children, per se, jumping through some hoops, whereas before they said completely not. So they kind of strengthened paternal family rights through that as well. And but in this gun case, they said that, hey, they talked about kind of on a whim on how these rights ultimately come up with, and a test kind of. And they said that a right that can be a constitutional right first comes from the states. And it says that, the states kind of figure out, and then once the majority of states start latching on and creating laws that are kind of the same, then you could say that, yeah, that's something that we can all grab onto, and this is part of the Constitution. Again, and it's hard because, liberty is an arbitrary word. And so depriving you of your liberty, what is that? And so they're saying that, if we all agree that, suckers are important, and we start creating laws about suckers and protecting suckers, then, I guess technically you could say that eventually suckers are a constitutional right. So if the state comes in and I'm holding a sucker and takes away my sucker, you could say that, hey, wait, you violated my constitutional right, because the states through time created a constitutional right. I don't like that reasoning either. And that goes back to what, is it in the Constitution or not? But again, what's hard is, what is liberty? And I could see the writing on the wall. I'm like, okay, they are teeing this up for Roe v. Wade, and Roe v. Wade is about to go away. And the problem that I had with that, and I think Clarence Thomas came out with that decision, was I think that, so in my personal opinion, because of the lack of legal like strong legal reasoning in Roe v. Wade, I think that that was a political decision in my mind personally from judges, where it should have been left to the legislatures. So I think that this is the other side of the spectrum too, because um, we so there's, I mean, pretty much, if you look at the voting when it comes to a president, it's always really close races, and it's almost 50-50 as who votes conservative, who votes liberal. But that's not how it works with all states. I mean, most states are genuinely conservative. So I'm concerned that that decision is a political decision as well and ploy, because they're saying, because most states are conservative, then they've essentially made it so they've left it up to conservative states to decide what is a liberty interest. And even though, you have California that has 45 million people, and Wyoming that only has like, you know, not that many people, and other small states, because they're bigger, because there's so many more conservative states, they could just look at it and say, oh, well, all these conservative states have these laws, and so there's a liberty interest in this. But these lesser liberal states, even though there's high population states, but there's less amount of liberal states, there can't be a liberty interest because not that many states have latched onto it. So that is an issue I have with the conservative. I think that was a political decision, and that shouldn't have any play in the Constitution. And I think what they should have done is just said this isn't in the Constitution, and just left it at that, instead of coming up with this new test that they came out with. So I think, yeah, I'm not a fan of that either. So now let's get to Jackson v. Dobbs. So this is the decision where they struck down Roe v. Wade, and so they what they tried to do, because the thing is, you have all these decisions now, like that I've talked about, that are grounded in this right to privacy. So if you overturn that logic, that Ninth Amendment, that penumbra right to privacy, and that lack of logic, if you overturn that, then you are stripping out and overturning all those decisions too, and saying that yes, states can tell you whether or not to have contraceptives, whether or not you're married. States can enforce sodomy laws, um, and and so that is, I mean, and obviously the conservatives saw some good to some of these decisions, and so what they tried to do, and was try and differentiate again abortion from some of these other decisions. And so their decision is just going through and saying that the argument wasn't even done at when Roe v. Wade was issued. There were states that had all these laws banning it, making it criminal, and they kind of do the opposite of what they did in Roe v. Wade, and cherry picking history. So they cherry picked the conservative history on abortion, and they said this issue wasn't settled, and there are a lot of people that were saying that abortion was illegal. So how could you give this right when states were saying it was like when it was a criminal activity? How could you have just afforded people this right? So that But they tried to just say, well, this is just abortion, and they tried to tailor it. But also, in the opinion, they take a hit at the right to privacy, and they do hit on that and the illogicalness of it. And I think that really is um, the crux of the issue, was that right to privacy issue. And they do mention that too, and say, really, you can't just step back and squint at the Constitution and say that there's a right to privacy and just, essentially let judges amend the Constitution. So they do take a hit of that, but they, in their holding, they just say, well, this is specifically just related to abortions. But um, despite that, I mean, they came out with, and it's hard to, just so you know, to overturn, for a Supreme Court to overturn itself. And Supreme Court has created rules on how to overturn itself. But they said that, this is just like the bad cases that we have overturned, Plessy v. Ferguson, um, and that this is a situation where it needs to be overturned. But the issue is now, and this is important to know, is that attorneys are going to latch on to them critiquing that right to privacy. And all, I mean, even though they didn't flat out overrule all the other cases, the writing is on the wall. And really, there is no logical reason now, if that's been overturned and that's part of their reasoning, there's really no logical reason to not overturn the other cases too. So that can be scary, because we have gay marriage that has, now they came out and used that and said, yes, this violates right to privacy. And so now that that has been gutted, there's no reason for them to come out and say that, yes, gay marriage is now, there's no right to privacy in gay marriage, allowing states to come out and regulate it. And so that's kind of where we are. And so where we are now is where we were pre-Roe v. Wade, where states are allowed to regulate abortions again. And I mean, the issue with Roe v. Wade too, and so there was another case that came out. And this should be mentioned too, is because of that science decision they came out with, is science changes through time. So in the 60s, maybe a baby couldn't live outside of the fetus first trimester, but times have changed. Medical improvements have been made. So that's the issue, is science changes, and it's not, so it's something that really can't be founded on a legal, so this legal decision was founded on science, a changing target, a moving target. It was founded on facts at the time, instead of on the law that shouldn't change. And so through time, I mean, science changed, and babies could start to live longer, at a shorter time outside the fetus. And so there was another case, Casey v. Planned Parenthood, where they try and grapple with that, and it really left everyone in, because so the first trimester, second trimester, third trimester thing was refined, but it just left it to this arbitrary thing on, no clear parameters on where the liberty interest was for the baby and where the liberty interest was for the woman, and when those crossed, and who had stronger rights. And so it was this arbitrary things that courts didn't even know what to do with, and how to determine, strike down laws. And so there was, with the new decision, Planned Parenthood v. Casey, it was an unworkable case at that point too, because it wasn't first trimester, second trimester, third trimester. Judges were essentially, again, forced to be the fact finders on science, and be like, okay, well, this baby could have survived based off what we know, and what has been presented to us. And so, yeah, so now it's back to the states, but I mean the problem is, and what led up to Roe v. Wade being overturned was, everyone latched on that, hey, we're going to get this conservative case, and a lot of conservative um, states started coming up with really wild abortion statutes that, I mean, some were saying that at conception, abortions were, life happens and abortions legal, and they were really trying to test it to attack this. Um, and so now we have some states that have some pretty really radical, hard conservative, um, and focused on the fetus and not the woman. Like Texas has a really hard abortion one as well that criminalizes it, where essentially most women have to leave the state, but also they can be charged with a crime if they do conduct an abortion outside the state. So that's back to where we are with abortion. And I think probably what they set that up as too is, well, let's let the states figure it out for a while too. This isn't a question that should be decided now, but with that gun case, if it was ever picked up down the road, they could just, like I said, what they did with is just look at all conservative states and say, oh, well, all these conservative states have these types of abortion laws, so this is what it should be, or just say, and come out with a decision that is more pro-conservative later on, and even enforce that harder, and have that affect the entire United States. I don't think that should happen, but yeah, so that's where we are essentially. That's Roe v. Wade. That's how everything went down. Um, and so, in my mind, again, just putting the abortion topic aside, just legally, logically, it wasn't founded on good, solid constitutional analysis that got to where we were in the first place. So when people, so if you don't understand that background, I mean, you may think that it was a political ploy for the conservatives to strike it down. But in my opinion, um, it was a very bad, solid, unsolid ground with Roe v. Wade. And so just from a constitutional analysis, that was a low-hanging, snaggly tooth that was really easy for conservatives to strike down. Um, and and I mean, it stinks for pro abortion people, and having to deal with that, and um, figure out what to do with their lives if they need, and essentially making it so they have to, decide, do I have to move to this more liberal state? Do I have to get out of the state to make decisions that I want to? But that's where we are right now. Roe v. Wade, 14th Amendment, I think that's a very important topic, because a lot of people, just hear that the Supreme Court made it illegal, the Supreme Court made it legal, but when you step back and understand the whole thing, it's not necessarily how it was. It was just, um, was there a right to privacy? Was there a right that the states couldn't come in and regulate? Or is it something that states could regulate per se? And just because of how finicky it is, and how it is founded in science, and because it's such a hot topic, it probably is an issue. I mean, even though, for liberals, it's not fair because there's more conservative states, so you're going to have more conservative abortion laws. Probably is something that should be left to legislatures, state legislatures, to decide. I mean, um, and that's the way it should be. I mean, the Congress, I mean, if they wanted to, they could pass a law too on abortions. And but I mean, the problem, I guess the problem was it really put it in the hands of the courts, and the courts just said, no states, this is how it's going to be. You can't pass laws that go into the first trimester, or even maybe into the second trimester, um, and and so it kind of allowed judges to make the decision on abortion too, where they probably shouldn't have, in my mind, and it really should be left up to legislatures to look at the science and to debate it and to come up with the right legislation for their citizens, and should be left on the debate table for everyone, because it's such a hot topic, because essentially they took the debate out. And I think this is one issue that is just, again, so hotly contested that it is something that should be debated and should be worked out, and should be left to science, and let it evolve, instead of being stuck in this law that has from the 1960s, and should be an evolving thing as we learn and understand more, how life works in the fetus, and also understand more on the women's side, their rights, and their scenarios, and situations where one may be needed for them, and to help protect them, and that should be taken into consideration on both sides. So that's all I have for now. Thanks for listening. We'll talk to you next time. And remember to like and subscribe to get more legal analysis, and we'll talk to you next time.